All right, we're going to get a little geeky today. We're going to talk about federal court appellate process and why something that just happened involving the Joe Biden ghost gun regulation dealing with incomplete, partially completed frames and receivers and weapon parts kits is a big deal. It's going to be inside baseball, super geeky about timing, and an attempt by the Department of Justice to slow roll all their gun cases to the Supreme Court until they get a chance to replace Justice Sam Alito or Justice Clarence Thomas with a Joe Biden or Gavin Newsom pick. Stay tuned. We're going to talk about what just happened in the Fifth Circuit Court of Appeals out of Louisiana and Texas. Hey folks, I'm Mark Smith, host of the 4Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, got to get a little geeky here. Just to step back, remember, when you're dealing with legal cases, you have substantive issues, meaning like, was a contract breached? Does that law violate the Second Amendment? Does that law violate the First Amendment? Did the person commit a murder? These are substantive questions about substantive law, like what is the law? But there's another critical thing that one needs to be aware of if you're a super geek involving Second Amendment cases. That is the process in which a case moves its way through the court system. That is sometimes referred to as the process or procedure. Civil procedural rules, federal appellate procedural rules, criminal procedural rules. You see what I'm saying? The reason why this is important today is because there is tension going on in the courts. Specifically, the Second Amendment community, in my opinion, if you support the right to keep and bear arms, you want to force as many Second Amendment related litigations through the court system as fast as possible, either to win on the issue, i.e. strike down a gun control law, which is just in and of itself good, and or to get that particular issue to the current Supreme Court, which obviously has proven itself to be respectful and favorable to the text of the Second Amendment, the right of the people to keep and bear arms, and not looking for excuses to simply not treat the Second Amendment with the respect it deserves as part of the Bill of Rights. So again, what's going on here is, as I see it, the anti-gun movement in America is doing everything they can to slow roll, to slow walk the process involving gun rights in America. That's one of the reasons why they're desperately trying to involve experts in all these cases. And we're going to do a big video on this soon, but no experts allowed. Do not embrace experts, okay? No experts. Okay, with that said, something has just happened in the Fifth Circuit Court of Appeals involving Joe Biden's ghost gun regulation that's very good for the Second Amendment. Specifically, the Fifth Circuit Court of Appeals has granted a motion to expedite and enter what's known as the mandate. The mandate. Now, when a case starts in the legal system, it starts as a lawsuit in the federal district court, or it could be a criminal case in the federal district court. The federal district court makes some sort of a decision. It goes up to the U.S. Court of Appeals. The U.S. Court of Appeals for that circuit makes a decision. And then, of course, depending on what happens next, it could either be appealed by virtue of a request for cert petition to the U.S. Supreme Court, or it could simply die there, because most cases die at the Court of Appeals level because, it's just not going to go to the U.S. Supreme Court because the court takes so few cases now. Now, with that said, when you're dealing with like this ghost gun regulation, we know what's going on here, which is the Department of Justice and Merrick Garland right now, because of an unfortunate decision by Justice Barrett and Justice Roberts siding with the liberals, the ghost gun regulation by Joe Biden, which governs the transfer and sale of partially completed frames and receivers and weapons parts kits, that regulation is in effect. So every single day that the U.S. Supreme Court does not get involved with the issue involving Biden's ghost gun regulations in, for example, the VanDerStock case, which is what we're talking about today, or the Black Hawk Manufacturing Group case, which is again what we're talking about here today, every day that goes by where the Supreme Court does not get involved and say this is illegal is a good day for the anti-gun movement. It's a good day for the Department of Justice because their ridiculous regulations requiring background checks and all this stuff for parts of guns, all of these regulations are in effect. So from the Department of Justice point of view, they want to go as slow as possible, okay? When it comes to the ghost guns. And they want to go as slow as possible with all other Second Amendment cases because their ultimate goal, of course, is, in my view, and I've said this publicly before, so I'm not going to hide behind anything now, is their goal is they hope that two of the older Supreme Court justices, the quote-unquote conservatives, Justice Clarence Thomas or Justice Sam Alito, they want them to leave the court, and they want to replace them with another Justice Brown Jackson that's going to be a knee-jerk liberal and is just going to mindlessly say whatever the progressive left wants in America, regardless of what the law says or the Constitution says. It just doesn't matter. They're just going to vote their liberal views, regardless of what the rule of law says. Typical left-wing effort on the courts. That's what judicial activists do on the left, and that's all they ever do. It's very easy. You put any law professor, virtually any law professor in America, not me, but any law professor in America on the Supreme Court if you're a liberal, and you're going to get the same outcome in terms of the way they vote in cases. So with that said, the Department of Justice is trying to slow walk things. The good news here is in the VanDerStock Blackhawk manufacturing cases, you may recall, the Fifth Circuit ruled in favor of the Second Amendment. Specifically, they said that the ATF regulations on these issues was illegal and thus had to be enjoined or had to be something. So what they did is they've entered that order that says, hey, this is illegal, and now they wanted to send the case back to the district court for the district court to do a remedy, come up with a remedy, and the two remedies available when the ATF exceeds its legal authority or any administrative agency exceeds its legal authority, it can either enter an order to vacate, also known as vacatur, which means that under the Administrative Procedure Act, the entire regulation nationwide is no longer effective, period, full stop, ab initio, because it was illegal. The other way they can do it is they can enter an injunction that's only specific to the parties involved in the case and enjoin the ATF and the Department of Justice from enforcing this regulation against the specific people specifically involved in the case. So again, what I think is going to happen here is that this case is going back to the district court. I suspect that the judge in the district court is going to enter an order to vacate the regulation involving frames and receivers and to enjoin DOJ from enforcing this rule against all the parties associated with the case. But as you recall, because of that 5-4 decision by the Supreme Court many months ago, where Barrett and Roberts sided with the liberals, they basically have said that any lower court decision to vacate this regulation or to enjoin this regulation is to be automatically stayed, which means to be put on the shelf and paused. But I think what's going to happen here is the district court's going to enter an order to vacate this regulation because it's already been found to be illegal and exceed the authority of the ATF, and they're going to enter an injunction as well. That's my guess. They will probably do both. I'm guessing. Don't know, but we'll see. That's my guess what they would likely do. And then Department of Justice will, I'm guessing, wait as long as possible, the last possible day to seek an appeal to the Fifth Circuit. The Fifth Circuit will get this case. They will recognize the importance of the matter and that people are arguably going to prison for something that is illegal, i.e. an illegal law. And I suspect the Fifth Circuit will move with speed to affirm or tinker with the remedy of the district court. They will then enter an order saying we approve the district court's remedies or will we tailor it in some other way, but they will immediately enter an order. And then, of course, that starts the clock ticking for the Department of Justice, who will likely wait till the last possible day to seek cert from the U.S. Supreme Court, all trying to hope and pray that the composition of the current Supreme Court changes. Now, the news today, again, is that today the Department of Justice, I think, was hoping to delay having to act on the VanDerStock case because there's a long period of time between the time a court of appeals enters an opinion and the time what is known as the mandate issues. Now, the mandate is a legal document that a court of appeals enters that sends the case back down to the lower district court. So the idea here, as I see it, was if you delayed the issuance of the mandate, every day that the mandate did not issue from the Fifth Circuit Court of Appeals was a good day for the Department of Justice, because it gave them another day where they could enforce their illegal laws against American citizens. So what happened here is the Fifth Circuit was asked to speed up and issue the mandate faster than they usually would, and they agreed to do so. And I'll put a link to this order down below. Specifically, what the three-judge panel in the VanDerStock and Blackhawk Manufacturing Group versus Merrick Garland case did is they issued an unpublished order that says as following: given the government's stated lack of opposition, it is ordered that appellee's motion for issuance of the mandate forthwith is granted. It is further ordered that the alternative motion to issue its mandate if no petition of panel rehearing or rehearing en banc is filed within 7 days of the issuance of its order determining the motion is denied as moot. But the critical thing here is it is ordered that the appellee's motion for issuance of the mandate forthwith is granted. So the mandate has now been issued. That means that the VanDerStock and the Blackhawk case are now going back down to the district court for the district court to come up with decisions associated with the remedy. And until that happens, there's no way to get it to the Supreme Court. And again, the way to view all of this machinations is there is a race to the Supreme Court, in my opinion. If I were a Second Amendment lawyer handling Second Amendment cases, let's say, in court, then I would rush these cases as fast as possible to get to the Supreme Court as fast as possible. And any delay I would view as good for the anti-gun community and for the government gun controllers. So the fact that the Fifth Circuit issued this mandate decision so quickly, and this is going to speed up the process, is a big but modest victory for the Second Amendment community, because it's these procedural things that you have to pay attention to speed things along. Now, it may seem really geeky. It may not seem like a big deal because we're not talking about, history in 1791, but these little battles that the Second Amendment community wins in the big Second Amendment war do matter, because it could be the difference between, who knows what's going to happen down the road. But the faster, like the VanDerStock case and the Blackhawk case gets to the Supreme Court, the faster, in my view, the Supreme Court is going to declare that ATF regulation is illegal and unconstitutional and may not be enforced. And again, that's why, in my view, DOJ wants to delay and drag the process out as long as possible. And the Second Amendment community and the gun community, in my view, should want to push these cases as fast as possible, which I'm going to digress one real quickly. Again, which is why you don't want to get into, you don't even want to talk about experts, you don't want experts, you don't want to hire experts or any of that stuff if you're handling the Second Amendment cases, because it does nothing at all for you substantively, and it only delays and drags out your case, and you totally don't need them. But we'll do a whole video on that separately involving experts. But if you're a Second Amendment plaintiff, in my view, you don't even want to think about experts. You don't need experts at all. You can get anything you need in as a legislative fact on appeal. And if you're in front of a district court judge that's asking for experts, you're probably going to lose anyway. So don't buy into the delayed tactics of the anti-gunners. Just say it's unnecessary. We have nothing more to say about the issue, and then the judge will do whatever they need to do to rule against you. But anyway, with that said, big news, but procedural news out of the Fifth Circuit involving the ghost gun regulations. I'll keep you informed. We'll see what the district court does. That'll be the next step in this journey, hopefully back to the Supreme Court. And yes, I do think there's an excellent chance that the U.S. Supreme Court will hear the Joe Biden ghost gun case of VanDerStock and Blackhawk manufacturing in the term of 2024-2025, but we got to get the court, I would say these Second Amendment plaintiffs got to get that case back up there to the Supreme Court, and they're going to have to move with speed, but I think it's quite doable if I'm looking at the timeline right here, right now. Okay? All right, folks, hope you're doing a little bit something here today about the process of cases moving through the system, and if you haven't subscribed, please do so. Don't forget to follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.